Hi, today Monica and I are going to run through some COVID-19 frequently asked questions that we receive, phone calls and emails about, some over the last year, some more recent comments that and questions that we've received. Hopefully at the end there'll be some time left that we can answer some questions for you. So Monica, I'll start with, what do you advise a caller or someone who emails us regarding employees who are exhibiting symptoms of COVID-19? Do they need to quarantine?
First and foremost, it is a policy decision, and every city is going to need to develop their own exposure and quarantine policy. We have samples of that on our OMAG website. If anyone needs to reference that, we've got a sample of that. But the city should consider the CDC guidelines in any state or local ordinances when developing their exposure policy. The CDC advises that employees with symptoms of acute respiratory illness and a fever should stay home. They can't resume their activity until they are free of a fever that is 100.4 or greater using an oral thermometer, or no longer have signs of a fever, free of any other symptoms for at least 24 hours without the use of fever-reducing or other symptom-altering medicines such as cough suppressants. So those are the CDC guidelines that would lead an employee back into the workplace following a COVID-19 illness. Obviously, I always defer to the medical personnel. So if an employee has a physician who has provided some information that would indicate beyond the symptoms that the employee should continue to quarantine, then we're going to defer to the medical reports on that.
Okay. What if the employee experiences symptoms at work? What would you advise?
So if an employee is exhibiting symptoms at work, we want to get them out of the workplace. If that's really important if they work around other people, for sure. But even those who may work alone in the field, if they are having signs and symptoms of COVID-19, they need to go home.
What if the employee is telling everyone it's just allergies?
Yeah, because that happened to me. Actually, I was here for several days thinking that I had allergies, much like a lot of other people were having around here, and found out at the end of the week that I had been exposed and needed to be tested, and ultimately did test positive. So, I think that if you have an employee who says, I'm just having allergies, that's not unreasonable to think, well, an employee can have allergies. So I think, again, it's one of those fact-specific situations that just has to be evaluated on its own. There's no one case scenario that you can follow.
Okay, and I'll say the sample that we have on our website is really kind of a starting point. So every city is going to be different. Some cities had mask ordinances, some did not. Some cities have 3 employees, some cities have 300. So you're going to have to decide what's best for your city, considering all of those factors moving forward. So don't just take the policy as is and publish it. I mean, there may be a situation where that's acceptable, but obviously take a look at it and make sure it fits your city. And as the vaccines come out and we learn more about the virus, take a look at that policy and update it. There may be some things that were really restrictive put in place at the beginning of COVID-19 that maybe as a practical matter you could loosen up or lift at this point. So sure. I think for a little while that's going to be kind of an evolving policy. In a little bit we'll talk about vaccines and some policies you can have for that.
Yeah. So Susie, what if an employee's been exposed to someone with COVID-19? 2 issues here. One, does the city require the employee to quarantine? And if not, what if the employee feels like they need to self-quarantine?
So we've had the self-quarantine issue come up actually probably more now than we did early on, because I think early on it was kind of a no-brainer, and that's what everybody was doing. Everybody was taking the most precautions no matter what. Self-quarantine, if sometimes even if it was a third-party exposure, depending on the city. But now that vaccinations are more prevalent, we know more about the virus. We know or think that masks work, social distancing works. Employers have PPE. They have policies and practices in place in the workplace to significantly reduce the risk of transmission. So you mentioned that you had COVID-19 and you were at the office. We wear masks outside of our own offices. We all respect each other's space very well. We don't eat or congregate in common areas anymore. And I think that with all of those precautions in place, it significantly reduced the risk that you would have spread it to anybody at the office. So I don't think anybody was worried at that point, because we do take those precautions. And at this point, they're habits that we've developed over time. And so I think at least for the foreseeable future, you should keep those habits in place. But if you get an employee who says, I need to self-quarantine, I actually got quite a few calls around the spring break time on this, which makes you question, do people really need to self-quarantine, or do they just want time at home for spring break? I don't know. But I think you should always listen to the employees, try to understand all the circumstances without getting into too much medical detail. At this point, there's no requirement to pay them any sort of federal benefit for the leave. So I would just, if they're willing to use their vacation or sick leave or go leave without pay, if it's one of those situations, then I think you should consider it. Obviously, if there's a situation where they can remote work, look into that. But I think you should probably defer to the employee. If the employee brings in a doctor's note, obviously defer to the doctor's note. Let's see. Again, each city is going to have to address those on a case-by-case basis. Well, let me ask this. Can an employee involuntarily send home employees if they're exhibiting signs? So what if the supervisor sees the employee just, looking completely worn out? Maybe they've started with a cough. They're sweating, some of those typical signs of COVID-19, which could also mirror signs of many other viruses or allergies. Should the supervisor or other employees be proactive about noticing those things and maybe even sending someone home if they witness that?
Yes, I definitely think that if you have an employee in the workplace exhibiting signs and symptoms of an illness that looks like COVID-19 or looks like the flu, you can send them home.
Okay.
And it's probably wise that you do that, whether or not the employee does so willingly. You do have to think about the other employees in the workplace, and you don't need everybody coming down with an illness.
I think that's a big part of it.
Yes.
You want the other employees to feel safe, and there still really is, with a good, I wouldn't say majority, with a good portion of the employees that still have a lot of high anxiety around this. I know for me, my husband's type 1 diabetic, and so he had a lot of anxiety. We have 2 kids. We're trying to keep everything as normal as possible, but there's still that anxiety, and so you have to be considerate of the other employees at work as well.
Well, and if that employee who's exhibiting those signs and symptoms has no way of leaving the workplace immediately, let's say they've got to have a ride home, then just remove them from the other employees into an area where they're more isolated until they can leave the workplace.
I mean, and if you think about it, this is to some extent no different than any other virus or illness.
Right.
I mean, if, before COVID, it could have been the flu. It could
Yeah.
have been strep. It could have
Yeah.
been some other things. So we don't want to expose any employees to any of those things.
Right. I mean, I think, as you said, it's no different than any other illnesses that we've dealt with in the past during flu season and those kinds of things. It's just really the prudent thing to do. We don't need all of our employees becoming ill, and most of us have a sick leave benefit. That's what that's for. So
Yeah.
let's just be smart about that.
So talking about other employees,
Mm-hmm.
and maybe this is one of those things that's kind of changed with time, but we have received questions about, okay, I have an employee who tested positive for COVID-19. Do I have to notify all the other employees that they've worked with? Do I need to notify the city council because they were at a city council meeting with us? Like, what kind of advice would you give on that?
Yeah, so you have an employee who has COVID-19, they're removed from the workplace, they've been around other coworkers or officials or whoever. I don't think that you identify the employee by name, obviously, but I think you do notify anyone who may have come in contact with that person that there has been a potential exposure for them, and leave it up to them to decide how best to proceed, as long as they're not exhibiting signs and symptoms. Again, that happened here. I was in a board meeting the day that I ended up going and being tested and ultimately tested positive. We just notified everybody that there'd been exposed. I told them it was me, but we didn't have to. Just let them know that there's been an exposure. Let them handle that as they best deem appropriate for themselves. Talk to their medical physician and that kind of thing.
Okay, so how did you narrow down the group of people that you were going to notify?
So
of the exposure?
I notified everybody who I knew I had come in contact with. And, here at OMAG, as you said, we don't congregate in close spaces. We were in our training room with our board members, and we were definitely more than 6 feet apart. But because we were in the same room, I did let each one of them know, and my coworkers whose offices are around the area where my office is. I didn't tell people who were downstairs in the claims department that they might have been exposed, because I hadn't even seen them that day. And so, just kind of have to
I think
that
I've
out.
seen the rule that it's like anybody you've been in a room with for longer than 15 minutes in
Yeah.
close quarters. So I think there's just going to have to be some common sense
Right.
with that. And that's something you can also put in your policy to explain that if you've been in a room with someone longer than 15 minutes, or you've been somewhere where you haven't had to wear a mask, or you haven't worn a mask, or whatever situation that is, then maybe that's the situation where you notify the people
Sure.
who were there. I think maybe police and fire might be different. That might be a situation where you would notify everybody on the shift. Maybe not police, but fire, because they're living together. So, obviously each situation might be different, so.
Right. Susie, let me ask you about some other issues that we've addressed with city officials and employees. Should the city record hours of leave taken for COVID-19 in their current pay systems?
Yes, I think they should, mainly for just kind of audit transparency issues. Unfortunately, with the Families First Coronavirus Response Act, or the FFCRA, which we call it, it required any employer with less than 500 employees to give certain leave benefits. And we have a link to some of that information on our website if you want that. It expired December 31st. I have gotten calls from employees who said, I didn't know that they were supposed to give me this extra benefit, and I was off for one of those 6 reasons during that time period. Can I make my employer go back and credit me those hours? And my answer is yes. If your employer has less than 500, and most of our member cities do, most cities in Oklahoma have less than 500 employees. So if you had employees take leave for one of those 6 reasons listed in the FFCRA, then you need to go back and credit their sick leave accounts or vacation leave accounts appropriately. There's different levels of credits that they get depending on one of the 6 factors. So obviously, you know, for auditing purposes and transparency, like I said, I think it's a good idea that you keep track of who received FFCRA and for what reason they received it for. You may not ever be reimbursed for those, because what the FFCRA specifically did was say that cities cannot get credits like private employers for granting that leave and for paying that leave. So unfortunately, you don't get anything for it from the federal government. But, you know, there's still laws coming out about relief for COVID-19. And so maybe in the future, there might be some state relief or federal relief that you could. And so if you've kept track of it, whether it's in your payroll system or on a spreadsheet, then you're going to have easy access to the information you need to present that for reimbursement. I don't know if that's going to come to fruition or not, but good reasons to keep it.
Well, and as attorneys, that's who everybody is here with us today, we want to have accurate time records regardless of you know, whether it's in the FFCRA or something else, so that if somewhere down the road you're challenged on how you've kept your time and attendance records, you want to have that record. So I think just your basic rule should be always keep track of your time and attendance records, and that way you've got the proof and you don't have to rely on your employee or somebody else coming in and telling you what happened during that period of time. You've got the record.
Yeah.
So I think that's just a good rule of thumb regardless of the circumstances.
Yeah, and I don't know how many times in employment law we tell everybody you've got to treat everyone the same. And so if you have someone who does file a lawsuit and say, I was treated differently than this other employee because they were allowed to work remotely and take all this time off and they still have a ton of leave. Well, if you have a record that shows, yeah, because under the FFCRA, we had to give it to them,
right,
and you were not in that same situation.
Right.
And so you're able to prove moving forward that you did not treat them differently. You were paying them and treating them in accordance with federal law.
Right, right.
So that opens the door to the discussion about working remotely and payroll records and time records, and how do we make sure that we accurately track what's going on? Because one of the issues that came up with remote working was, how do I make sure that my employees are actually working the required number of hours? So we've had to deal with that quite a few times. So what are your suggestions about what an employer, city can do to make sure that when they have employees working remotely, they're not running afoul of, employment laws, FLSA or FMLA and things like that?
Right. Well, I think first and foremost, you've got to have a working from home policy that outlines how that will work for your employees. You need to have those set criteria for your employees. You also, so critical, to have a vehicle for tracking the hours that non-exempt employees work. Because if they're not at work, but they're working from home, you've got to make sure that you are paying them for all of their time spent working, and which leads to the third thing that you need to do if you're a supervisor of a non-exempt employee. Check in with them. It's easier to do when everybody's at work in the same place, but when everybody's working from home, you check in, make sure that they are getting their work done. Have assignments that you give to them, and know that there's work that they can do from home, and that they're not just sitting idle and expecting to be paid sitting idle. That's not appropriate for any employee.
Okay, so you've referred to non-exempt employees. We get a lot of questions about this because there's a lot of confusion, even with attorneys, because you can't know everything, right? I mean, don't ask me a question about tax law or wills and trusts, because I'm not going to give you a great answer. But under the FLSA, they refer to employees, or they categorize employees by exempt and non-exempt. And there's different rules that go along with that about, work hours and overtime and things like that. And so for many, many years, I think employers used, I don't want to call it an excuse, but the reason they didn't allow non-exempt employees to work remotely is because employers are tasked with and required to keep track of hours and to make sure that they're only working their scheduled hours every week. And it's hard to do when you can't see them every single day. A lot of people refer to non-exempt as hourly employees. But can you kind of unpack that idea of exempt and non-exempt and why that's important in the remote working scenario, and why attorneys and city officials and employers should be understanding of that when they allow employees to work remotely? Right.
So there are fewer issues really with those who are deemed to be exempt under the FLSA. Those exemptions, there's various categories for exemptions. A lot of times you'll hear people call them salaried. That's really not an appropriate reference for an exempt employee. They're exempt. So there's fewer issues with that, although you want to make sure that they're doing their work as well. The issues really to be careful about are for those non-exempt employees. Their working hours are probably the most important, because according to the FLSA, a non-exempt employee has to be paid for all of the hours that they work, and they get overtime for any hours they work over 40 in a work week. And that work week can vary, but typically, Friday through Thursday, Monday through Sunday, whatever it is, you have a set work week. And you count the hours that are worked in that work week, and anything beyond 40 has to be paid at the time and a half overtime rate. So you've got to have a clear policy on what the work week is and what the work hours are that need to be specified in the policy. As an important side note, in your job descriptions for each of your positions, you should say in there whether or not this position is an exempt position, exempt from overtime position, or a non-exempt position under the FLSA. And again, don't confuse the hourly versus salary designations as substitutes for non-exempt or exempt, because again, the FLSA does not recognize those terms. It's critical to use the appropriate terms to avoid any confusion about how you're supposed to be paying your employees. If you have questions about that, you can Google the Department of Labor website. They've got fact sheets that cover just about any issue you could think about under the FLSA, and there are fact sheets available out there regarding exemptions from FLSA overtime. And there are tests, there are fact sheets that have the tests that you can run through for each position so that you can figure out whether or not they're exempt or non-exempt. So you're not left to just try to figure it out on your own, that there are plenty of reference materials out there under the Department of Labor website to help you get all of that squared away.
Okay. I always, in my mind, early on, I say exempt from, exempt from overtime. And that's how I remember the difference between exempt. So employees who are exempt from overtime. If you're non-exempt, you're not exempt from overtime. So you have to keep track. But as a practical matter, how would you suggest, or do you have some ideas about how a city can help kind of keep track of the number of hours in a day that employees are working? I've seen two different situations. Obviously, you have the employees who are just so much more efficient at home, and they just work. And so they are actually getting more than 40 hours a week or 8 hours. Their 8-hour days extended to 10-hour days. And then by the end of the week, they've hit this, overtime. And so, but I've also heard of situations where employees kind of piddle around the house and aren't getting in 8 hours a day. I know there's no magic bullet for that, but what are some suggestions about maybe trying to keep track and get a handle on that?
Yeah. Well, first, I think you've got to have some mechanism in place that requires employees to check in the morning and check out in the evening. So that way you know when they've started and when they finished. How they fill in the in-between with their work is really something the supervisor has to stay on top of. And so again, check in with the employees, know what tasks they're doing. There just has to be so much communication when everyone is working from different places. Just talk to them and, what are you working on today? The supervisor should have an idea about how long that work is taking. I think something also that is important, and this should be in your policy, is that for those non-exempt employees, obviously we want them working during their working hours, but you also need to have something in your policy that talks about what they do outside of those working hours, because working from home, they have their computer, the technology is there so they can access their work, emails, and those kinds of things at any time of the day or night. If they're doing that, that's work. And if you know they're doing that, then and you've not corrected them, then you've blessed that. But either way, it's work time and they have to be paid for it. Now, if you have it in your policy that they're not supposed to be checking emails in the evenings and on weekends, and then you find that they have done that, you still have to pay them for it, but then it becomes more of a performance issue, and that has to be addressed through some kind of corrective action. So really just have your policy in place that dictates their conduct during those working hours, check in the mornings, check out at the evenings, and know what they're doing in between through your communications with your employees.
Okay, good advice.
Susie, let's move on to questions about vaccines. One of the questions that we got early on was, can a municipal employer require employees to receive the COVID-19 vaccine? What are your thoughts about that?
Legally, the EEOC and OSHA have stated that employers may lawfully require employees to take the COVID vaccine or to show proof that they already have it. And the EEOC even went as far to say that it won't violate the ADA either, in the regard that you're asking for medical questions or asking for medical information from the employee when you receive it. As a practical matter, you better have a pretty good reason in place if you're going to require vaccines, mostly because we're governmental employers, and so just like drug testing, if you randomly test someone, you better make sure you're following the state law and other federal laws that go along with that, because it could be, a Fourth Amendment violation, because it's the government requiring something of employees or individuals. So there are a few preemptive things you can do. And by no means am I saying that no city should ever require vaccinations. I'm not saying that. That's totally a policy decision by your manager or your town board. Maybe you should probably develop a policy with regard to vaccines. I don't know how detailed that needs to be. Maybe that you encourage the vaccine if that's the route that the city wants to take. If it's mandatory, I would say you definitely need a policy. You need something that comes from the manager in a city manager city, or the council or town board in any other form of government, because I think it has to be a solid policy set by the city that this is a requirement. But one of the things that you have to think through is what's the fallout from that? So what are the consequences if employees do not get the vaccine? And if it's a requirement and they're not going to get it, then it could be that you have to terminate employees. And so I think you just have to take a hard look at which employees would that be? What does that do to your workforce? How much time are you going to have to spend rebuilding the workforce if you've had to terminate employees who didn't get the vaccine? So, that's one of the what ifs. So I always say, okay, well, let's think this through. What happens if you do this as a practical matter? So one, we just talked about, what if an employee refuses? What if an employee says, I have a religious belief that precludes me from getting vaccinations? You have to go into the, does it create an undue burden on the city to have employees who are unvaccinated? You probably should have pretty good proof of that. Maybe that goes back to, how many cases have you had in your workforce? Maybe how many cases have you had in your city or your county? The cases have been significantly reducing, and some counties are actually in maybe not green, but yellow at this point. Mm-hmm. So, lots of things that legally you would have to take into consideration to be able to prove that this one employee not getting the vaccine would be an undue burden on or cause harm to other employees. The same analysis would have to be done if the employee says, I have a disability, or I have a doctor's note that says I can't get the vaccine for certain medical reasons. Honestly, I would not suggest that you question that. Just as I wouldn't suggest you question their religious beliefs. I just think that's kind of a rabbit hole you don't want to go down, because then ultimately you'll probably learn more information than you need to know. And any decision after that, the employee is going to say, well, you made this decision or took this adverse action because you knew I had these strong religious beliefs, or you knew I had a medical condition. So lots of what ifs in that scenario. Honestly, I think you just have to think through the practical considerations of requiring all employees to get vaccines. And just on a personal level, I have lots of friends who have been vaccinated, and I have lots of friends who either refuse to ever get vaccinated or they're just not sure yet. And so to require someone to do it right now when they probably think it's a good idea, but they're just not sure, is not maybe the fair thing to do.
Yeah.
To force them into that situation.
Well, Susie, let's dive a little bit deeper into some of those what ifs. You talked about an employee who says they have these religious beliefs and that getting a vaccine would conflict with that. Does the city have to accommodate that employee who claims to have those religious beliefs that would be violated if they were required under your policy to have the COVID vaccine?
Yeah, so you would have to, go into some legal analysis here. If the city was adamant that this is what they wanted to do, this was the policy moving forward, this was the policy adopted by the council or the manager. So legally, you would have to, kind of go through the religious discrimination analysis. Is it a sincerely held religious belief? And would the accommodation pose an undue hardship or create harm to the employer?
What is a sincerely held religious belief?
Well, that's a good question. You would have to ask questions. So the EEOC has given some guidance on that. But what they've really said is don't count out a religion just because it's newly adopted, it's not consistently observed, or it's different than the other commonly followed tenets of individual religion. So what they said is basically it can be anything, and don't count it out just because you've never heard of this religious belief. You can ask questions like, if the city wanted to go this route, you could ask questions to determine if it was a sincerely held religious belief. Like, how do you observe your religion? Are there other followers? Do you have any religious materials that you could show me that show or that can prove that this is truly your religious belief? Again, ultimately, the city might find out more information than they probably need to know. And so understand that in the future, any adverse action taken against that employee, this is going to be their automatic knee-jerk reaction, that you're doing it because I didn't want to get a vaccine because of my religious beliefs. So, just consider all those things before we launch off into determining someone's religion and if they have to get a vaccine.
In that same vein, you also mentioned employees who may have a medical condition that causes them to not get the vaccine. So what if you do have an employee who says, I can't get it because I have this pre-existing medical condition? What do you do with them?
Yeah, I think it's basically the same analysis. It's like, any other type of discrimination where the relief is some sort of reasonable accommodation. Again, the ADA has said if it's an undue burden on the employer, they don't have to accommodate. Again, it's going to be a fact question, I think. And so ultimately, if the city pushes it and requires the vaccine and they get sued because the employee had to terminate, either they constructively discharged, meaning they quit, basically because they felt like they had no other choice, or they retired. Again, that's like a constructive discharge. Mm-hmm. Or they were terminated. You better have a darn good reason, and you better have a policy in place that says, vaccines are mandatory, and this is the consequence if you don't get it.
Right. So over the last year, we have learned, at least here at OMAG, and I know lots of employers have learned, that working remotely is possible. We've continued our operation working remotely from our homes. But things are opening back up now, and so people are coming back to the office. We're expecting people to resume those activities. But what happens if you have an employee who requests a reasonable accommodation under the ADA to continue to work remotely? Can the municipality refuse to allow that employee to work remotely because of COVID-19?
Yes, get that question. So ultimately what happens when you do this analysis with religious beliefs and disability is ultimately what you're trying to reach is some sort of reasonable accommodation for that employee's beliefs. So if the city's adamant that you can't come to work if you're not vaccinated, then you need to enter into some sort of interactive discussion with the employee about before termination. You know, about, okay, well, can we work out something here? The employees are probably going to want a work from home scenario, if it's possible. Obviously, public works employees, police, fire, there's really not a work from home situation there. So that's probably going to lead to some sort of discipline, or not even discipline, just termination, because it's really not a discipline issue. This is a requirement for the job. If you can't do it, you can't work here. But so in those situations, yeah, you can refuse to allow an employee to work from home. However, in other situations, maybe office personnel or someone who does, I would just say typically, work in an office with a computer, maybe talking on the phone. We know we can even attend to meetings remotely. In a lot of cities, you can do that. In some little small towns, that's just not going to be possible. Right. So I think there are situations where you can refuse to allow an employee to work from home. I think even when you have office settings or things like that, I mean, if you've had employees off working remotely for any length of time over COVID, you're going to know the employees who thrive in that environment and those who don't. Both of those employees are going to feel like, well, or the one that has to come in is going to feel like, well, why do I have to come in when so-and-so doesn't have to come in? Well, so they need to clearly understand what the difference is. And legally, I think that's defensible.
Yeah, I do too.
Yeah. So let's shift gears just a little bit. But one of the questions we get, and we talked about this a little bit with just employee anxiety, but what if you have an employee who is just scared to come back to work and says, I'm not coming back, I refuse to come back to work because I'm still scared and have a lot of anxiety about COVID-19?
Yeah. So being scared is likely not going to be an excuse for refusing to come to work. Obviously, you would consider all of the factors that the employee wants to bring forward, but this comes up a lot, that you've just got folks who are scared. And if they've got some kind of a health condition, then that's something you need to talk about, or if they fall into one of those categories that deems them to be compromised, so to speak, then you talk about that and you consider all of the possible things, like under the FMLA, the ADA. You consider all of those things that you've got to make sure you've covered as an employer, so that you're not in violation of those laws. But if you have an employee who is scared, and other than just their fear, there's no basis for them not to come to work, I'll make a little plug here for OMAG's EAP, Employee Assistance Program. If you've got an employee who is having trouble coping with returning to life as it was pre-COVID-19, just by virtue of their fear, then let's see what other things are available to help them deal with that. One thing that the main thing that pops into my head is an employee assistance program, which we have here at OMAG and is available to every one of our cities who is a member or participating municipality here at OMAG. So we've got resources that would be available to help that employee work through whatever those issues are that are causing them to be fearful of returning to work.
Yeah, and you also mentioned FMLA. So anxiety potentially could be a serious health condition if the doctor so ordered it. But what if you have an employee who says, I have to work remotely because I have a spouse, like I have a spouse who has type 1 diabetes. What if you have an employee who says, I don't want to come to work and potentially expose myself, which may ultimately expose my spouse or my children with a serious health condition. Would FMLA play into that?
It could, although the FMLA doesn't require the employer to make accommodations specifically for an employee's disabled family member who may be at high risk. But again, it's going to be very dependent on what the physician might say, and depending on the situation in that moment, then they might have a qualifying health condition under the FMLA for their family member. And if that's the case, then you would want to make sure you've given them the time up to 12 weeks of unpaid leave so that their job is protected. And for those cities who may not fall under the FMLA because they're not big enough, make sure you've covered your own policies there, because what we see is that a lot of our cities, even though the FMLA doesn't apply to them, they may have adopted policies that are like what the FMLA requires. So again, just make sure you follow your policy, but I guess the answer to the question is yes, possibly.
Lawyer answer.
Yes.
Yeah. So let's talk about vaccines a little bit before we wrap up here.
Yeah.
So there are municipalities in the state, and I'm sure in other states, and private employers who are offering incentives to employees who get the COVID vaccine. Have you seen this in any of our member cities, and what does that look like as far as an incentive goes? Yeah,
so here at OMAG, we've got an incentive program now, and we're aware that Nichols Hills and Midwest City does as well. Those incentive programs, lots of options, you can be as creative as you possibly can, but offer some kind of incentive such as a stipend, paid time off, maybe discounts on health insurance premiums, that all of those things together would encourage an employee to go and voluntarily be vaccinated for COVID-19.
Okay, good to know. So, let's see, and I've seen that incentive be anywhere from $50 to $200, a day off, maybe time to recuperate.
I think that's really critical, that if your goal is to encourage your employees to get the vaccine, which I think that should be the goal, then I think at a minimum, if they require some time to recuperate because they don't feel well for a day or so after the vaccine, then give them that time. I don't think that while you can charge them their personal leave, why? I mean, that's kind of a disincentive, right? If they're having to spend their own personal leave, so give them that time. I think that's an important piece.
Yeah, I agree.
So Susie, is the municipality liable if it requires employees to return to work and the employee contracts COVID-19?
I have done some research on this issue, and I will give the maybe answer. Again, obviously, it's going to be dependent on the facts. But some of those facts that I think the courts would take into consideration is, what kind of precautions did the city put in place for employees? Did they require PPE? Did they offer PPE? Did they put a policy in place that resembles some of the CDC guidelines? Some cities actually required employees for a long time to have their temperature taken before they came in, and things like that. There are a few cases out there. Let's see. Basically, what they've said is if a city can show that it's followed state and federal guidelines on combating the virus, it's not likely to be legally liable. Now, I'm not talking about any kind of workers' comp benefit. I'm just talking about negligence. some of the causes of actions that have been thrown around are gross negligence, creation of a public nuisance, wrongful termination, and then the constructive discharge for wrongful termination. And those are going to come about because the employer is alleged to have not taken any precautions and are still requiring employees to come to work. So those employers that don't require masks, they haven't put any kind of barriers or policies in place about staying 6 feet apart or not congregating in common areas and things like that. One court took the position that a private action for public nuisance cannot be maintained where the injury is so general and widespread as to affect the whole community. Now that language does mirror some of the workers' comp language, which is part of the reason there's kind of some conflicting language in the workers' comp statutes. And caveat, I am not a workers' comp attorney, but I have talked to one, and that there is some language very similar to this that basically takes a virus like COVID-19 out of it, puts it in that widespread affects the whole community category, and so therefore it's not something that would have been contracted at work. It's very hard to prove that you contracted at work. It's not impossible to do. So I think that's kind of an ever-evolving thing. I think it's probably more likely a potential workers' comp claim than it is the city just generally liable for a gross negligence or creation or a public nuisance lawsuit. But again, bad facts make bad law.
Right.
And so if you have an employer who just refuses to believe that COVID-19 over the last year was as serious as it was and didn't take any precautions, then obviously they open themselves up for that liability.
Right.
So another issue that we haven't really gotten into too much, but we've had a few questions, is about the American Rescue Plan Act, the ARPA. I did talk to Mike Fina a little bit about this. It's still in the works. The Treasury Department is still working through the rules and how to push it out and all those logistics. So I think we will work with OML, or OML, we'll work together with some other organizations to push out as much information as we can once we know about it. But if you could just give everybody a brief update about what we do know at this point.
Yeah, so what we do know is that, as you mentioned earlier, with the FFCRA and those paid leave requirements, those expired at the end of December of 2020, and those were not extended through the ARPA. So employers in the public sector are not required to extend those at this point. There are some private sector allowances for payroll credits and that kind of thing if they voluntarily do that, but that does not apply to governmental employers. So if we've got municipalities who are doing that at this point, again, that would be voluntary and should be done according to policy, but it's not required under the law. There are some other provisions in the ARPA related to COBRA benefits. If you have somebody who has to be laid off or loses their job right now because of COVID-19. I won't go off into all of that because that is so highly specialized, but be aware that there are some COBRA provisions in there that may apply. I'm not aware of any municipalities who have had to deal with that. But if it comes up, we can try to help through that. There are also some additional unemployment benefits through there, but again, not an issue that we've had to deal with. So most of what is contained in the ARPA really is more of a private sector employer thing.
Okay. And having talked to Mike a little bit, there's a lot of infrastructure items built into that bill, and hopefully after having gone through the CARES Act, and the reimbursement process for that wasn't always easy for everybody. But hopefully we can have a more streamlined process for distributing money to cities and towns, whether it's the state doing it or directly to the city. So we'll find out more about that in the future.
Yeah, that's still to come, but the latest that I've read on the distribution of those monies is that the first round will be coming around May 10th or 11th, something like that, and it will go out to those major cities, but it's still yet to be determined how they will roll it out to those beyond the Tulsas and Oklahoma cities.
Okay, good to know. Well, that wraps up our frequently asked questions section. Please obviously let me or Monica or Jeff or Matt know if you guys have any questions or follow up. We will have some resources on our website, regarding some of the things that we talked about today. So thanks for listening.